everyone, good evening. You're watching A Billion Ideas with me, Maria Shakil, this Saturday. Today we focus on the 50th Chief Justice of India, D.Y. Chandrachud, and the road ahead as he helms the judiciary for the next 2 years. Justice Chandrachud was sworn in by President Droupadi Murmu on Wednesday. A man who famously describes dissent as the safety valve of democracy, he has been a part of several constitution benches and landmark verdicts of the Supreme Court, including judgments on the Ayodhya land dispute and the right to privacy. He has been a part of benches that delivered path-breaking judgments on decriminalizing same-sex relations, the Sabrimala worship case, and paved the way for the Permanent Commission for Women Officers in the Armed Forces. Recently, a bench headed by him expanded the scope of the Medical Termination of Pregnancy Act to include unmarried women. The new Chief Justice comes from a storied family and has big shoes to fill. His father, Yashwant Vishnu Chandrachud, holds the distinction of being the longest-serving Chief Justice of India. Progressive reforms has been the signature of Justice Chandrachud as a judge of the Supreme Court. And as the Chief Justice, can he chart a similar path for the judiciary as he navigates the social, cultural and political dynamics of India? Before I bring in top jurists of India, here's a look at the legal journey of the 50th Chief Justice of India.
Justice Dhananjaya Yashwant Chandrachud was sworn in as the 50th Chief Justice of India on Wednesday. He succeeds Justice Uday Umesh Lalit, who demitted office on the 8th of November after a brief tenure of 74 days.
सामान्य नागरिक की सेवा करना ये मेरी प्रायोरिटी है. अब आप आगे देखते रहिए. कार्य से हम सारे नागरिकों के लिए कार्य करेंगे.
Son of the 16th Chief Justice of India, Yashwant Vishnu Chandrachud, D.Y. Chandrachud was born on November 11, 1959. Justice Chandrachud pursued a BA with honours in economics from St. Stephen's College and did his LLB from the Campus Law Centre at Delhi University. He obtained an LLM degree and a doctorate in juridical sciences from the Harvard Law School. Justice Chandrachud practiced as an advocate in the Supreme Court and the High Courts of Gujarat, Calcutta, Allahabad, Madhya Pradesh, as well as Delhi. He was designated as a senior advocate by the Bombay High Court in 1998 and served as Additional Solicitor General of India from 1998 to the year 2000. He served as a judge of the Bombay High Court from March 29 in the year 2000 and the Chief Justice of the Allahabad High Court from October 13, 2013 until his appointment to the Supreme Court on May 13, 2016. Justice Chandrachud has been a part of several constitutional benches and landmark verdicts of the top court, including the Ayodhya land dispute, the right to privacy, the decriminalization of same-sex relations, the Sabrimala case, and even the expansion of the scope of abortion laws. He now helms the highest court of the land, facing the daunting challenge of reforming the judiciary and critical cases, including petitions against the government's flagship Agnipath scheme and the power tussle between the Delhi and union governments.
Joining me on the show, Satyapal Jain, Additional Solicitor General, Geeta Luthra, Senior Advocate of the Supreme Court, Ujjwal Nikam, Senior Advocate of Bombay High Court, Tanveer Ahmed Mir, Senior Advocate of the Supreme Court. Geeta Luthra, I'm going to begin with you, ma'am. Justice Chandrachud has been one of the most prolific judges in the Supreme Court, being part of over 220 judgments. Which judgment or order, according to you, has been truly landmark?
So there are many landmark judgments. I believe that I like the LGBT judgment insofar as what he says is that we cannot correct the wrongs of history, but we can at least give the right direction. So in the sense that Justice Chandrachud has tried to make giant leaps in human rights, in rights of minorities, in gender justice, I believe that truly that judgment which is Navjot Johor's judgment,
Yes.
is perhaps one of the most outstanding judgments, but I would be wrong if I actually pinpoint only one. I think the Sabrimala, I think that his rationale in all his judgments, whether it be Puttaswamy or in Sabrimala, are unique, and the proportionality principle which is there in law but which he laid down so strongly in Puttaswamy is extremely telling for the right to privacy. So I believe it is his logic and the beauty of the expression and the manner in which he puts it across that I think each of his judgments are unique.
Okay. Tanveer Ahmed Mir, the 50th Chief Justice, is taking over at a time when the government has criticized the collegium system of appointments of judges as lacking transparency. Do you see executive and judiciary perhaps being on the collision course now onwards?
Thank you, Maria, for that question. I firmly believe that the executive has always had a problem with the independence of judiciary as the third leg on which a robust democracy is to stand. That has been happening previously also, and let me assure you that these noises will be certainly made in future and during his tenure also. I think that the executive is a bit apprehensive about this great honorable Chief Justice in terms of the great jurist that he is. And I should say that one of his hallmarks is recognition of individual liberty, balancing of rights between law enforcement agencies and individual rights. So we have a lot of expectations from the new Chief Justice, which includes, filling up of vacancies in various high courts. But I think the most telling ones will be where the executive is in a tussle with people who they don't like or their political opponents. We have new kinds of challenges in our society. For example, demolition of houses of innocent citizens, or just for people who have been accused of some commission of criminal offences. Now, these are great challenges before the highest court and the Honorable Chief Justice, that whether the dispensations in power in various states or the centre will be given a long rope in trampling upon the individual rights and valuable rights of living with dignity and honour of citizens of this country, irrespective of whatever spiritualities and religions they follow.
Yes. Okay.
We have seen Justice Chandrachud writing a legendary judgment in recognition of individual liberty in journalist Arnab Goswami's case. So I expect, as a lawyer, that he will keep up this stride in whatever matters that will, reach his desk and his court.
Yes.
And he's there to send a very strong signal in the society that the judiciary is there as protector of rights of the people and not as an institution which is going to buckle down before the might of the electoral vote being gained to a particular party.
Okay, let me bring in
that essence.
Yes, let me bring in Satyapal Jain as well. Dissent is a symbol of vibrant democracy. Voices in opposition cannot be muzzled by persecuting those who take up unpopular causes, Justice Chandrachud wrote in his minority opinion. And there has been several such differing views in several 220 judgments that he has overseen. One of the historic dissent was also on the Aadhaar policy as well. And as Geeta Luthra and Tanveer Ahmed Mir were pointing out, he is someone who's upheld the individual rights, the right of minority. What do you think will be the big challenge going forward, Satyapal Jain?
See, I totally agree with my earlier learned colleagues. He is one of the finest judges we have in the Indian judiciary. His command over the language, his zeal to protect the fundamental rights of all sections of society, his zeal to make submissions, to write judgments with logic. You may differ with the logic, you can differ with the judgment, but he has a logic in his own judgment which you need time to understand. I think that he will prove to be one of the best Chief Justices of this country. So far as the challenges before him are concerned, I think there are 2-3 serious challenges that he will have to face. Number one, increasing the number of judges, meaning thereby decreasing the number of vacancies and decreasing the number of cases which are pending both in the Supreme Court as well as in the High Courts. Now, as per my information, out of about 1,000 judges in the different High Courts, there are about 300-350 vacancies which are already there. Supreme Court has vacancies. I am not saying that simply by increasing the number of judges in different High Courts and Supreme Court, the pendency of the cases will decrease. But certainly as the head of the institution, परिवार के मुखिया and the judicial सरकार के मुखिया के नाते he will have to take those steps, and I am very confident that he is competent enough, he has the capacity enough to take all these challenges and he will be able to come out of it. I am very confident that my friends were citing some conflict with the executive and all that. I don't think any apprehension of that. Okay. Even in the judiciary, you were just referring to a minority judgment. Judges differ. One judge says this thing, another says different thing. It doesn't mean there is some collision or there is some sort of conflict and all that. Right from 52 onwards, Punnu Swami's case, there have been number of constitution benches, full benches, even 3 judges benches, where judges have differed. So if the judges differ, then there is no challenge to the institution. Then how can you presume that if the executive differs, there is something which is unexpected?
Yes. So, he has also said, Ujjwal Nigam, that it is the responsibility of all decision makers, not just judges, to ensure that the law does not become an instrument of oppression but remains an instrument of justice. And as the top justice of this country, as the Chief Justice who will be in office for 2 long years, the lawyers on the panel have already explained the challenges, a possible collision course with the executive. The big challenge, of course, is of the pendency of the cases as well. What do you think is something that you will be expecting out of Justice Chandrachud?
Let me tell you very frankly, the moment Justice Chandrachud has assumed the charge of a CJ of our country, he has said one very important sentence. He would like to do the work instead of talking much. That is a very important message which he has given to the society at large.
Right.
Now, see, I am conducting the many serious cases in the state. But what I find that everybody talks about the conviction. But what's about the appeal against acquittal? There is a huge pendency, whichever the appeal against the acquittal in all high courts. But nobody is paying very serious attention. Even in the High Court, nobody bothers about that appeal against acquittal because the appeal has been preferred by the state. What I expect to you, that Honorable Justice Chandrachud has to pay attention whether a regular bench can be constituted to decide an appeal against acquittal. Because I have conducted one very serious case as a special public prosecutor in Maharashtra. That judge has acquitted. It's a case of a double murder. The trial judge acquitted all the accused, and we preferred an appeal, and High Court reversed the judgment, and they gave judgment after the 15 years. So what is the use of that judgment? Because the deterrent sentence, it is not only to the punish to the very criminal, but to give a strong message to the like-minded people. This is the very deterrent purpose of the punishment. But that purpose is being frustrated because appeal against acquittal are not being taken on priority basis. So I expect that Honorable Chief Justice would pay much attention to the state priority also, so far as the appeal against acquittal, number one. Number two, about the collegium system, that also you raised that question also.
Yes.
I must concede here, every system has certain advantages as well as disadvantages. It is said in English that every kitchen has a cockroaches. But in order to have a good food, we try to remove the cockroaches by using the strong insecticide. So no doubt, I must fairly concede that in collegium system also, there are certain drawbacks. Now we have to see how Honorable Chief Justice Chandrachud would like to improve that collegium system. Because in judiciary, transparency is more important. And if there is no transparency, the common man's confidence will be shaken at large. And therefore, we have to see what our new CJI would like to make certain changes in the collegium system. What's about the judicial accountability bill? That is also pending with the government.
That's right.
So there are the many problems, and I'm sure because Honorable CJI is a very dynamic person and he's a versatile person. He knows each and all the problems of common man, and I'm very confident that he will try to solve all these problems.
Okay, before I go back to the panelists, let's listen in to Justice Chandrachud. He spoke at the Hindustan Times Leadership Summit 2022.
Basic framework for the functioning of our courts. What kind of challenges do we really face in today's times? I think the first challenge that we face is the challenge of expectations. And that's a huge challenge for the court. Almost every case comes into the lap, every social issue, every legal issue, and I dare say a large number of political issues fall within the adjudicatory jurisdiction of the Supreme Court. The reasons for that are numerous. Very often, the government is the largest litigant in the court, and the reason why the government is the largest litigant in the court is for the simple reason that we have, over the last 70 years, bred a culture of indecision. A culture of indecision at the lowest levels of government. So be it a case of a pension, a case of compassionate appointment for a woman who has lost a spouse while in service, who wants a job in a government department, there's always a tendency. There's also a culture of distrust. And that culture of distrust leads many of our top decision makers to be very careful about taking decisions having a bearing on very high stakes. Would there be a vigilance inquiry if the person were to be promoted or were to lay down office? Would there be possibly an allegation that you made a concession to a corporate enterprise and which would be investigated into 10 years down the line? So a variety of reasons in the Indian context have led to a culture of distrust and therefore a culture of indecision on the part of public functionaries. Now, all those cases are therefore deferred to the court. We'd rather have the court decide than us taking a decision. That's one of the reasons why the courts have a large backlog of cases within the fold of cases that we decide.
So, Geeta Luthra, here is the Chief Justice speaking about the burden of expectations, and that is perhaps forcing the decision makers to delay decision and leading to that mistrust.
He's absolutely right. You know, today in the courts, if you go to the courts, you will see that the government is the biggest litigant. In fact, day after day, petitions are thrown out saying, you know, there is no merit in it. You filed it after 200 days. You filed it after 500 days. And this is because government officers, to actually protect their backs and to be non-decisive, become file pushers. And the ultimate aspect is it lies in the lap of the court. Now, while I say that, I also want to take a leaf out of what Tanveer said, which is the aspect that the question of a clash, possible clash between a strong executive and a strong judiciary. Now, in actual fact, they should go hand in hand, and in the past, most decisions by the courts are respected by government. There are rare decisions where the state will amend the law, will try and oversee the law, but as and when the court actually lays down and quashes an act or a notification, in most cases the government takes it gracefully. There will be cases, there will always be those cases. A strong executive normally does not coexist with a strong judiciary. I am hoping that the future will show a strong executive but an equally strong judiciary.
That's a point very well taken. Tanveer Ahmed Mir, will you add to it that the need of the hour is that you have all the pillars that hold this democracy strong? Legislature, executive, judiciary, and also the media.
Actually, when we look at our country and our constitution, it is the people of India who are supreme at the end of the day. It's not a government who is in power or a dispensation in power, which is the supreme. And therefore, any government in a state or a center has to realize that they are there to serve the interest of the country at large for every citizen. And that should percolate down. Now, in that, political zest that we are in power, now it should not be that you're seeking to railroad everybody and you're trying to conduct yourself that if you are not with me, it's like if you don't like my way, then the only way is the highway.
I get that.
If you see a couple of years earlier at the time when Honorable Justice T.S. Thakur was the Chief Justice and a particular dispensation was in power, during that time, not even a single recommendation of appointment to the Supreme Court went through.
Yes.
Why? Because the government blocked everything. Now, what we expect is that the legal community is always there to serve. If there is a strong legal community, you will see a strong Chief Justice. You will see strong judges in the High Courts. You will see strong judges in the Supreme Court.
Okay.
Likewise, people who get elected to the parliament, they better realize that they are there to serve and they can't have unsatiable greed to grab power and to retain it at any cost.
Okay.
So some amount of clash is bound to happen.
Okay.
But we are there to protect the interests, and that is what we expect. And I'm sure
if the people are
every
supreme,
Chief Justice, including Justice Chandrachud,
and if they are kept
work hard towards
at
achieving
the
those
center
objectives
of all the decisions, and that's where India should be headed. Satyapal Jain, I have just 30 seconds for you. Please go ahead.
See, I totally agree with my learned colleague as well as Mr. Kiran Rijiju, who said that it is the will of the people that should prevail. In Indian system, both the legislature, the executive as well as the judiciary, they are supreme in their own fields. Ultimately, it is the constitution which is supreme. When we talk of will of the people, I'll just give one example. The National Judicial Appointment Commission Act was passed by both houses of parliament unanimously. Congress, BJP, Akali Dal, CPM, all agreeing to that. Still the Supreme Court said with the ratio of 4-1, no. It is against the basic structure of the Constitution of India. The whole executive accepted it. There was no challenge to that. So, but question will be, what is the will of the people? The act passed by the parliament as a whole or by the honorable judges? But still, because the power ultimately lies with the judiciary, entire country accepted that. And so far as the appointment part is concerned, there are plus and negative points of both the systems. The government system also, the collegium system also. Let us find out a rational way where discrimination at any level is eliminated.
Will there be discussion on that rational way? Let's see. Thank you so much for joining me, Geeta Luthra, Ujjwal Nikam, Tanveer Ahmed Mir and Satyapal Jain. At the Hindustan Times Leadership Summit, the Chief Justice of India also spoke about why judges speak in different voices, especially during the course of hearing of any case. Listen in.
Judges often come across to people as old-fashioned octogenarians because of our black gowns and, of course, the imposing regalia. When you combine that with a sonorous voice, legal language which, like the doctor's prescription, the doctor's prescription only the chemist can understand. So legal language which only the lawyers can understand, it can be a heady combination for boredom, utter boredom. But to borrow the lyrics of that song from Doris Day and Frank Sinatra, we are among the very young at heart. So I'll begin with that this morning. I'm very often posed with questions, and you also read them in the media ever so often. And those questions are, why do different judges speak with different voices, particularly in the Supreme Court? Why can't these guys agree on one set line of approach? Why is it that in very crucial cases there are multiple voices speaking from within the same court? Another criticism or question is that why do you have to deal with whether or not to grant bail to somebody who has stolen luxury cars or maybe cycles, or who is in possession of 5 kilograms of opium? Why should you be really opening yourself up to deciding these cases? Or sometimes you're asked, why is it when we look at the dais on the benches of our courts, whether it's the high courts or the Supreme Court, that you see more men than women?